towards critical mass. And since we started a little late, let's get started. Um, l- uh, I guess it was actually or like last week. Um, I was listening to podcast Strict Scrutiny and heard an interview with our guest today, Shaun Ossei-Owusu, who's a law professor at Penn, and has just written a great book called The Law on Trial, and went right out, got it. Actually, it's a real page turner, and read it that evening. It is I think, a really excellent book coming from a lawyer to demystify and unpack the ways in what is always presented to us as neutral is in fact reinforcing a lot of things that go against our values. And so it's really, and I was telling Sean yesterday that if I'd ever gone to law school, I would have wanted him as a professor, but that's another story. Um, anyway, so we'll get started, and Sean will tell you about his background and how he got to this place, and then we'll have a conversation.
Great. Thanks for having me, Mike. Thanks for
Sure.
the kind words about the book and about me. Very much appreciate it.
Sure. Just tell us about your background growing up and how you decided to go into law and how you decided to write this book.
Yeah. I'm originally from the Bronx, New York, born and raised. And I grew up in the Bronx in the late 1980s, early 1990s. And when and growing up during that period, I didn't have the language for what was happening, but I had a sense that, my community was being treated differently than others, and I slowly got better language for it as I got older, as I left the borough, went to Manhattan and went to some of the, went to some of the suburbs outside of New York and, New York City and New Jersey. And then I went to college at Northwestern, and there I think I really, I majored in communication and African American studies and really got better language about inequality, economic inequality, racial inequality, in the legal system. And at that point, I was very much interested in going to law school at the time, but I also had a kind of burning intellectual curiosity that I didn't think law school would satisfy, in part because the first year is a prescribed curriculum. And then after the first year, there's about another half semester, some would say some would say full year of courses that you don't have to take, but that you should take. So administrative law, federal courts, evidence, corporations. And so I ended up doing a master's program actually here at Penn. And I taught at a charter school to kind of buy myself some time to figure out if I really wanted to go into law or going to pursue a PhD. And I decided on the latter and started a PhD program at Berkeley in African American Studies, but still had these burning questions about the legal profession. And so wrote a dissertation about race and public interest lawyering and ended up matriculating into the law school. And after law school, I practiced in DC. I worked at Sidley Austin, the law firm, and I also did a secondment at the Legal Aid Society in DC. And then ended up in academia, did a postdoc at Columbia, and now I'm at Penn, where I've been for the past 7 years and teach courses on the legal profession, civil rights, and the welfare state.
Great. It's a really impressive background and like really sets you up to for these insights. So you go through this in both an overview, but also the different familiar categories of law. I thought if you could should give that sort of, you know, brief idea that goes threads through the whole book. And then I thought, given where we are right now, we'd start by talking about Calais and how that fits into what you were writing.
Yeah. So really, the one of the key arguments of the book is that legal education endows students with a really important, uh, but what I call tragically necessary skill, and that's the ability to separate legal arguments and legal reasoning from their kind of social and moral consequences. And I call it's necessary because the analogy that I like to use is similar to medicine. And so when a patient comes in describing certain kinds of pain to a doctor, the doctor has to engage in certain kind of translation work and translate that pain into a diagnosis, into reimbursable Medicare or insurance codes. And in the legal profession, we have to do something similar. We have to translate a social problem into different legal categories. And so it's necessary. But part of what I argue is that oftentimes the human, social, and moral consequences fade deeply into the background in ways that exacerbate inequality. And so the first half of the book focuses on what that looks like in the first year curriculum of law school. And so at many schools, the first year curriculum includes contracts, torts, property, criminal law, constitutional law, and civil procedure. And so, in the context of something like torts, a tort is simply an injury or harm. When people think about it, they think about slip and falls and car insurance. And in the course, much of the discussion tends to focus on issues of negligence, um, to the neglect of big social harms such as domestic violence, and state violence. And so there's an actual category in law called constitutional torts that focuses on when state actors engage in violence, think police brutality. That gets cordoned off as something else. And so in law schools across the country, there are students learning about the legal category of harm without focusing on two of the biggest perpetrators of harm, which can be the state or into partners. And so that's just to give one example in the first year curriculum.
Sure. And your chapter on constitutional law is really important and very relevant to Calais, which came down last week, but also the last 20 years of the Roberts Court. So, why don't you sort of talk about how you see all of that going? Like, yeah,
Yeah. And so really in the constitutional law chapter, part of what I talk about is how constitutional law is taught with the premise that we're operating with a functional democracy. And when we look at the different branches of government, some people would disagree with that presumption, whether
right,
it's at the Supreme Court, which people describe as obviously partisan, Congress, which has been dysfunctional for more than a decade, and obviously the president's, the executive office and everything that's happening with the president, as well as the executive agencies that operate under him. So that's the kind of the larger background. But I mean, I think this voting rights decision that was issued last week, is a good example of some of the patterns that I'm interested in. And so, again, the book is talking about how legal reasoning narrows really big real world problems, things like racial discrimination, voting rights. It narrows these real world problems into specific legal tests. And so in voting rights cases, that can mean focusing on whether something fits into a test, um, as opposed to what's really happening on the ground. And so some of the critiques of the decision is that it's completely oblivious to the reality of racial discrimination in voting. And so oftentimes what you see in a case like this one, as well as many of the kind of big hot button issues that the Supreme Court decides on, is that the outcome can feel very much disconnected from the stakes, even when the case is being framed as just applying the law.
right. I think one of the things that you said to start your answer couldn't be more important, um, which is that it not just for constitutional, but I think for all of what you're doing, is it assumes a functioning democracy,
Yeah,
and it assumes that, um, the Constitution is like, has to be taken as a given,
right,
right? And without examining the values that have been smuggled into it, so that when you do that kind of abstracting and legal reasoning, you can end up with what in the real world are horrible conclusions. And I think I don't know, I speaking for myself, but I think a lot of people feel really trapped for the last while because we know this isn't right. But when we hear often lawyers who share our values, we can't get past those unexamined assumptions, right? And that there's just something like intrinsically perfect, about or unchangeable about the Constitution. So what you're describing, right, certainly must not be the dominant perspective when you get together with your fellow professors. So tell us a little like how do those conversations go? Or do you have them?
I
Well,
definitely have them, and, my colleagues differ, in their view. I mean, I think so there's a few challenges. I mean, I think one key challenge is, you know, um, part of, I think, what law professors are trying to do, I think particularly constitutional law professors, but I think more generally across subject matter areas, is, impress upon students that it's just not politics. I think it's easy to conclude that all of the kind of big Supreme Court decisions are just tied to politics, and there's some work that suggests that that's not quite right, and I think that's important because part of our objectives are is as instructors is to teach students the law, and so I have a line in the book where I'm just like, whether you're on the left or on the right, and you want to abolish police on the left, or you want to abolish the Department of Education on the right, you can't do that without learning the legal basics for why those agencies exist. And so part of what we're trying to do is not have students just think as everything about politics. But some would argue that some professors overcorrect in that desire to want to teach students about the internal logic of the law. And so I think that's something in terms of like conversations that I have with my colleagues. It's about, how how intellectually honest should we be about politics playing a role in legal decision making? And I think underneath that challenge is student reception. We're in classrooms with students that come from diverse racial, class, and for this purposes, ideological backgrounds. And so professors can be scared. That's actually the verb that I want to use. Scared of seeming like they're putting their thumb on the scale of an issue. And so I think besides kind of being intellectually honest about what's happened, I think that there's a fear about student reception and students understanding professors as being woke or overly conservative. And so those are the kinds of conversations that I find that we sometimes have. And then I think some of the conversations that I have with professors are about, what their stakes are. And I think I've been critical of my colleagues nationally, not my colleagues just at
yeah.
Penn, but colleagues about what our own implications, like how we are implicated in what's happening. And I think that there's a way that law schools and law professors think that what's happening in our legal system, the more troubling aspects, have little to do or bear no connection to how we're training our students. And so that's a fight
Right.
that I get into with some of
Yeah.
my colleagues.
As I was here listening to you, it occurred to me that there's another oft used metaphor that you used that like your premise about it has to be a functioning democracy, which is that professors don't want to put their thumb on the scale in all of this. which hides the fact how lopsided the scale already is,
Right.
right? That like you visualize and a scale evenly balanced, right? And you say, "Oh, I don't want to put a thumb on that,"
Right.
right? Whereas in fact, that's not what the scale actually looks like, right?
Right. Right.
And so you're basically sort of laundering the what's an imbalanced scale into what's pretend is balanced. Um, but there's another part that what you said I think is and one of the things that we're just getting to know each other, but that I always try to come back to, which is the way in which our vocabulary gets in the way of really understanding things. And so when you said that, the question of whether you can say that politics affects the outcomes, right? Politics is a very elastic and shape-shifting word. And I would sort of get your reaction. I think most people, when they think of it, they think about partisan politics, right? That the court is just playing partisan politics. And I think, especially this one, that's highly correlated. But if your like scientific hypothesis is that, there are going to be a lot of instances where that is rebutted, right? But there, that's only because it this current court, I would argue, is less a partisan court than one that reflects the interests that created the pipeline that got them there, and that often there's division within that coalition, right? So that there are times, just like in the Senate, not all Republicans agree. And we don't then think they're not self interested in what they're doing, right? We don't say, oh my God, the Republicans aren't partisan because they didn't all vote the same way. But that's because we understand that they have different interests. And I think the same's true with this six, right? There are a couple who are just straight out there religious fundamentalists. And like some of those cases don't get the full thing. But I want to like offer a couple ideas to get your reaction to about you can never like no one is can pretend that they're completely independent of their time or their values or those things. There seems to me there are a couple ways to describe it that you can get much closer than we are now. And one test would be whether major changes to the way we all have to live our lives are made 5-4, 9-0.
Mm. Yeah.
That that when it's 5-4, there's something that it should like that's a problem, right? That they can change whether you can have an abortion or whether you can have districts that reflect your interests when there's no effort to compromise, no effort going across. And that's where I find like the comparisons with Brown disingenuous because
Mm.
that was unanimous, right?
Yeah.
Second test I'd offer is
Right.
whether the what politics is doing an umbrella for is a democratic politics where you get Brown in the civil rights movement reflecting a democratic movement that is acting nonviolently and going through the processes it's supposed to be, or whether it's not, it's going through electing senators via money and all of that,
Mm.
do it. Right. Anyway, so we'd love your reaction on those.
Yeah. I wanna make sure I follow because it sounded like you were saying more than 2 things, but
Yeah.
it
Oh,
sounded
no,
one.
2 different tests, 2 different tests. One test is, like, right off the bat, if it's 5-4, I like to say, like, this is a terms of service constitution where we have no idea what can upend our life and only lawyers get to decide. Or when it's 9, oh, it usually or 8-1, whatever, it usually reflects that our understanding in the world of what's right, like interracial marriage or one person, one vote, or those kinds of things, they're catching up with where society is often, and they're doing it unanimously on purpose so that we feel like it has legitimacy. But when you do it 5-4, like you're basically saying the other four don't know shit about the Constitution, right? And they're just going to yank away the world the way you knew it yesterday.
Yeah. Huh. I mean, it's tricky because I can think of a category of close call cases that shape out in a variety of different directions,
Yeah.
as well
No,
as
some of them were terrible. I'm just saying like not to mechanically decide how to look at it. But those are two screens that I don't really think people use, right? And I think that could tell us more.
yeah. I mean, I think so. I mean, I think I mean, the challenge I think the challenge for me for the kinda 9081 decisions is kind of like pre New Deal.
Right, you
There
got
are a
Plessy
lot
and
of those
yeah, no, you
decisions.
have Plessy and Dred Scott, which are that, but that gets to the second test that I had, which is whether they're reflected like the civil rights cases and Plessy, right, were not reflective of all the sacrifices and everything that went into the 14th, 15th Amendment, the Civil Rights Act of the time, right? It was over, right? It's both tests together.
Got it, okay. Yeah, I mean, I can definitely see that, especially as I think about some 5-4 kind of like post-civil rights 5-4,
Yeah.
5-4 opinions, 6-3. And I think, part of I think what you're alluding to too is tied to the judicial nomination process, you know, which up until, you know, some would say Justice Thomas, some would say Judge Bork,
Yes.
but
Yeah.
really up until about 40-ish years ago was relatively uncontroversial but has become more politicized, which then changes the human inputs on the court and end up, impacting how these votes shake out in a variety of different cases. And so I think that the kind of politicization of the nomination process, to your point, the kind of entrance of big money in that process has ended up shaping the composition of the court in ways that influences the votes.
Yeah. So I think that that point is so important and something that people who are of more recent birth can't imagine is for how long in through the 20th century Supreme Court nominations were uncontroversial. And and I would argue that until Bork really, um, and here's where I think politicization masked what was actually going on, is that until Bork, the process of presidents deciding who to nominate was the norm was to nominate justices who would get bipartisan support.
Yeah.
Right? It wasn't that suddenly everyone caught like a partisanship mind virus at that point and decided, well, we've always done approved the other party, but now we're going to play hardball. It's that for the first time, really, someone who had like remember for folks, I was talking to someone earlier this morning and realized I had to update people. Like when Bork was nominated, right? It was like a a decade or so since he, was the one who stood up on the Watergate Saturday Night, Saturday Massacre, after the Attorney General and Deputy Attorney General refused to fire the independent prosecutor against Nixon, who said, I'll fire him, and had a whole body of work basically saying all the quiet parts out loud. And that was what was unprecedented. It wasn't unprecedented if you hear from the right that suddenly the left was attacking Republican nominees. It's the substantive package in Bork, right? And then after that, as you know, they stopped looking at ABA recommendations, like all the things that guaranteed that the nominees would be reasonably appropriate for everybody, that they weren't going to actually hijack the country. You get these high stakes. So I think that's a big part. That's where the change happened. Um, the I was going to say the anyway. But I think sorry. I'm going to come back to that maybe. But on another chapter that I thought was really important for people to read, and that I thought you handled very well, was to talk about labor law. And we were joking the other day that that used to be a major part of the curriculum and was kind of central. So why don't you sort of fill people in on that chapter?
Yeah, so, there's a chapter in the book, that is in the part of the book there's a part of the book that focuses on law firms, and there I describe the 3 kinds of work that lawyers and law firms do. One is kind of transactional work, one is regulatory work, and one is litigation, which is what people tend to think of when they think of lawyers. And so the transactional chapter focuses on healthcare. The regulatory chapter focuses on the environment, and environmental regulation, and the litigation chapter focuses on the workplace. And part of what I was trying to do across those chapters is describe big areas of human life that impact all of us. You know, everyone everyone desires to be in good health. Environment shapes our quality of life, and our workplace also do, also plays a role in our economic and social well-being. And so within this chapter, I try to describe the ways that and I say, much of the work that law firms engage in is inoffensive, uncontroversial, and pretty mundane. But, at law firms that have employment and labor practice groups, because their clients tend to be deep pocketed corporations, they're sometimes defending interests that come into conflict with the interests of workers and the general public. And so the first half of this workplace chapter focuses on employment discrimination. So think discrimination on the basis of race, sex, disability, and the ways that these law firms engage in class action litigation that can crush the claims of people who are claiming that they were discriminated against. And the second half of the book, which you're alluding to, is what people describe as union busting. And so, some of these law firms have practice groups that focus on preventing the creation of labor unions, or to the extent that they exist, crushing the claims that are brought against them. And initially in an earlier version of the chapter focused just on those employment discrimination lawsuits. But, a part of what I talk about in the book is, my mom was in a union, in a hotel union in New York City. And I think more generally, because of the decline in union membership, um, over the past few decades, I worry that the American public doesn't have the best sense of the importance of unions as a general matter, but more specifically in combating corporate power. And so, really, what I try to do in the chapter is describe how the work of law firms influences the workplace by setting the parameters around what kinds of discrimination claims people can bring, but also the ability of workers to kind of organize in service of their collective interests.
Right. You know, I think there's an one of the things that you do in that chapter and the others for other issues is that I think there's a way in which most people who are in like either the academic bubble or the Washington bubble think
Or
something
New York bubble too.
New York, well, yeah, New York bubble too. That um, we just passed a policy that makes X illegal, problem solved. And I think, for example, when you talk about wage theft in there, right? People don't understand how much wage theft there's going on in the country, right? It's another one of these things that people in those bubbles think is not a problem.
Yeah.
And you describe pretty vividly how corporations get to use the law to steal our wages. And that's, I think, a good example of you to unpack of what you're talking about, where even in those moments when our small d democratic process can accomplish a good law, that's not the end of the story, right? That's the beginning of the story going over to the legal system where you should describe what happens next.
Yeah, and so, there's so many different forms of wage theft, and, the most, like, innocuous version is just clerical errors, small businesses that don't understand kind of Byzantine wage regulation. So that's one version, but even in that version, oftentimes workers don't have access to resources that will allow them to challenge that wage theft or just may not even know about it. So even in the most generous version of wage theft, there are problems. And then I think in the more egregious versions, we typically, when people think of wage theft, they think about, the restaurant industry and employers skimming money off the top. But part of what I described is how, big companies have also been engaged in wage theft. And so there have been lawsuits against Uber for taking money that was supposed to be dedicated for drivers and keeping it for themselves. That's
Right.
version of wage theft. And again, in those instances, um, individual workers don't either don't have the knowledge or the resources to get a lawyer to reclaim what they're legally entitled to. And even in an instance where they might recognize that there's a legal violation, the various rules tied to forming class actions, which again allow people to come together collectively to pursue remedies that they might not be able to pursue individually or that might not be worthwhile for a lawyer to pursue. So you think someone who has $50 stolen from their
Right.
wages, that's not going to be something that's going to motivate a lawyer to pursue. But if you're talking about a class of 10,000 people who have $50 taken, then it's a different proposition. And even in that context where you have 10,000 workers who say, I have this wage theft claim, part of what I describe is, again, these the kind of niceties of class action law make it so that it can be harder for those workers to, again, pursue what they're legally entitled to. And part of that is tied to the law firms that are defending these corporations and the law firms that, are zealously advocating for them and trying to create the conditions for their clients to have a legally favorable environment. And part of what I'm trying to do is in the book is say, like, these are the law firms and the corporations are legally entitled to pursue that course. They're not engaged in anything illegal, at least in that description. But just because they're not engaged in something illegal doesn't mean that they're not engaged in something that's socially problematic, nor does it mean that the average non-lawyer or average human being need to be beholden to that idea of legality.
Right. And I think also, and this sort of gets to your toward the end of the book, I can't remember the exact word you like cause litigation, right?
Yeah.
But in the example you were just talking about something doing something that like is quote legal but objectionable, it's right that often it wasn't the original intent for it to be legal, but through precedents, the law the interpretation of the law becomes such that the new legal is becomes objectionable, if that makes sense, right? That there's so many, it's not only in each individual case where I only lost $100, which is the difference between me and being unhoused, and what a attorney's willing to pay to take on the big company to get my $100 back, right? It's that the legal environment in which I'd even try has been changed over time to make it even harder in terms of forming a class or any of another other things. But in that next moment, you say, well, there's nothing I can do. The law says this, right? And that I think is another important dimension that readers would get from reading it, because the law is not neutral.
Right, right.
Yeah. So we're getting sort of close to the end. Other things we haven't covered that you're interested in conveying?
Yeah, I mean, there's a bunch of things that, I try to cover, in the book. One thing that we didn't talk too much about, is government lawyers.
Right.
And so there, in the book, I talk about, you know, w 2 kinds of government lawyers. First, prosecutors, who we tend to be more familiar with, local prosecutors, and municipal lawyers, so city and county attorneys. In the context of the former prosecutors, part of what I try to talk about is, these are important public actors who play a role in public safety. Um, but oftentimes they're narrowly trained to think about questions like, what can I charge this person with? What charges are supportable by the evidence? What can we prove? And those are important questions, but they don't fully capture the, you know, broad scope of the consequences of prosecution. So they might not ask, what prosecution might do for this person. Does prosecuting someone for this case make a community safe? How decisions like this specific prosecution add up across thousands in the aggregate. And so I try to spend some time talking about how prosecutorial choices, and the narrow ways in which prosecutors are trained beginning in law school can have implications for the general public. Also, to the point about municipal lawyers, these lawyers play an important role in helping city life run. And so, like what I say in the book is that, we tend to think of big civil rights laws like Title VII, the Voting Rights Act, but there are local and state laws that these lawyers are responsible for enforcing, and that's good. They enforce local employment and labor laws, local anti-discrimination laws, local consumer protection laws. But part of the challenge is these lawyers have the city as their client. So if you live in New York City or Philadelphia or Boston or any city, the city law department has the city as its client. And so what it means is oftentimes residents are bringing claims against the city, whether it be, police brutality claims, ADA accessibility claims, housing claims under the Fair Housing Act that are accusing the city of wrongdoing. Some of those claims are frivolous or not strong legal claims. Some are. And in those cases that are, you have a scenario where lawyers have the responsibility of defeating claims by legitimate civil rights claims by their clients. And to me, I think that's the interesting slash dangerous thing that we talk less about. I think prosecutors get more attention, but these municipal lawyers really shape city life in ways that I want to draw attention to readers.
So at the risk of, or taking the opportunity to make some of the who joined uncomfortable, I think that you should talk a little bit about like public interest um, law. And because you made some really interesting points, and I bet we have a few public interest lawyers listening right now.
Yeah, so this is one of the harder parts of the book to write about. I think in part because in terms of my scholarly
Yeah.
identity, much of my work has been about public interest lawyering. My next book is a history of public interest lawyering from the founding era to today. I teach social welfare
Yeah.
law, which is essentially a public interest lawyering course. Um, and it's the part of the profession that's most consonant with my commitments. And then part of what I say in the book is that, you know, there's an inherent challenge to criticizing public interest lawyers because definitionally they are engaged in a public good. They're fighting on the sides of people who are marginalized. And so it in some ways seems like misspent energy highlighting their shortcomings. But, in part of what I say is important in the book is there's a certain kind of intellectual honesty, whether we're talking about law firms, talking about legal education, talking about government lawyers, public interest lawyers shouldn't be immune from honest criticism of their shortcomings. And so there's a few things that show up, in the context of direct services. I kind of spend some time talking about how public interest lawyers have been empirically shown to subscribe to forms of implicit bias, how oftentimes their ranks can be racially homogenous or homogenous in terms of gender. And so some people call public interest law the pink ghetto because of overrepresentation of women. And there's a question about what does it mean when you have a sector of the field that is overrepresented by women, s- overrepresented by racial minorities relative to the rest of the profession, but still relatively homogenous. And it's also the most underpaid profession. I talk a little bit about how the adversarial ideal and ideas about zealous representation can lead public interest attorneys to actively lean into stereotypes that might be actually be beneficial for their client in the short term, but detrimental on a collective level. And so, the common example people point to is, if you have a client that's a client who's a father, a client who's a mom, leading into ideas about fatherhood or motherhood in ways that might be helpful but reify gender stereotypes. And then in another chapter of the book where I talk about impact litigation, and there again, it's tricky. So impact litigation is using the courts to achieve social change as opposed to being engaged in direct services like helping people with public benefits or representing them in criminal cases. And so in impact litigation, you can sometimes see organizations take problematic stances on issues. And it can, I'm going to be clear, it's problematic based on your vantage point. And so a nice example is the Bruin case, Second Amendment case issued by the court a few years ago that expanded the scope of the Second Amendment and was more permissive as it relates to gun ownership. There were some people who were against and more expanded ruling because they're concerned about more people having guns and what that means for public safety. And so you have racial justice advocates saying expanding the scope of the Second Amendment is going to be bad for poor marginalized communities. That's a legitimate and reasonable argument. And on the flip side, you have racial justice advocates, specifically public defenders, saying, look, it is strict gun laws that are unevenly enforced on minority gun holders that are as actually playing a role. So we actually need to have more expansive gun laws so that our marginalized clients aren't over policed. I think that's a reasonable argument too. And so part of what I try to describe is how there are some aspects of impact litigation. Another version, some people would say, is religious liberty versus anti-discrimination law that can lead public interest attorneys to be implicated in these larger social problems and questions of inequality that I think can be uncomfortable to confront, but I think are important conversations to have.
Yeah. And I think because if you hadn't read the book, I think part of what may have come across that that you do that didn't come across that you do is it's not to just the individual lawyers. It's that the system is kind of structured to reproduce the inequalities and injustices, that you're trapped in a system trying to do your best in a system that is actually meant to protect privilege. Um, but I want to, before you go, because now listening to what you were saying about what your next book is about, want to throw a question out historically. Um, the so everybody's or probably familiar with the Great Society and um, the work that was done. It like just sort of the burst of basically, from our perspective, good things that happened right in that Great Society stuff. Um, but the work of some folks like Elizabeth Hinton and others, and my own experience sort of coming in at the tail end, is that those programs to a great extent were also trying to channel people with complaints about housing or about fill in the blank to use the legal system instead of organizing themselves and being political, right? And so you have this period, and again, this is kind of crazy in contemporary terms, where the government was paying a lot more to legal services, and they were like really more robust advocates at that point, and but it really drained a lot of the grassroots power building that had been going on to like accomplish those goals collectively. So I'm curious if that resonates with anything you're planning to tell us in your next book,
Oh, yeah.
or what
Oh,
you
yeah.
think about.
I mean, that's part 4 of the book, the last 2 chapters. I'm actually the book will be published by Princeton University Press. I have to send it to them next month.
Yeah,
Yeah, so I talk about it, and, I think there's some truth to that argument. I think it's a bit complicated, and so, I'll start with the complication and then get to the truth. And I think
yeah,
the complication is, I think that much of the work that these federally funded public interest lawyers engaged in, was socially important in that enduring in ways that are important. And so, I think about a case, under the radar case, that people might not know about, but Singer versus Hamlin. It follows up Gideon versus Wainwright, the more famous case, which says that the state's going to charge you with a felony, they have to provide you with an attorney. You know, Singer versus Hamlin, litigated by
right,
these lawyers, and extends the right to counsel to misdemeanor crimes. And there were some subsequent cases that made that case a little trickier, but at its core, it allows in many states people who are charged with misdemeanor crimes, crimes that can lead to punishment of less than a year, to be entitled to a lawyer. And that's not small when you think
right,
about, things like, some of the disasters that we saw in a place like Ferguson,
right,
for example. And I can think of similar examples across consumer protection, housing, civil rights more generally, where there are enduring precedents that are byproducts of that work. Um, and so, in that sense, I think it's a bit complicated. But I think the point still remains. There's a way that the excitement around federally funded legal services did channel some energy away from movement organizing. And, what ended up happening is, by 1973-ish, legal services lawyers are winning so much at the Supreme Court and in lower federal courts, there's a backlash. And the backlash
right,
is led by, some Republican as well as Democratic politicians who want federally funded legal attorneys to focus just on bread and butter, garden variety legal disputes, an eviction here, public benefits claim there, but not larger systemic cases suing police departments or suing large employers. And
Right.
so I think that there's a way that the kind of over reliance on lawyers to solve social problems in the 1960s and 1970s in some ways came back to hurt left leaning progressive social movements because they didn't know how to respond when legal services got reorganized and when there was the creation on all the kinds of restrictions that these lawyers could do. So no desegregation cases, no voting rights cases, no abortion cases, no inmate litigation, no very limited ability to defend undocumented immigrants. And so I think they kind of struggled to adapt to that landscape in part because they hewed so much to this idea of lawyers as the people who could solve social problems. And so in that sense, I think that story is correct.
Yeah. And I want to be really clear because, like, no one like snipped this transcript part that what I'm about to describe is a process that I see happening over and over again in this country, but not by some grand conspiratorial design, is that whenever we as people get together and are so successful acting collectively to force a new law on the books to protect us, that we are really told that the story's over, that the law's been passed, you can go home, don't worry about it. And for a brief period, like you were describing with legal services, the it actually follows what we want, right? Because if you're a lawyer who wants to be legal services in the late 60s or early 70s, of course you realize that you need to sue the police over police brutality. Of course you need to do the things you were talking about. And then the people who like had to concede the law in the first place say, maybe that was a problem, right? And it went too far. And so it all gets cut back. But at that point, everybody's demobilized, right? And we see this long arc with the civil rights movement, right? Where for the last, arguably since Shelby, right? The There's no like standing army of activism to react to it, right? It was distanced in enough time and all sorts of other things so that it could be dismantled without there being a democratic reaction. Although hopefully we'll start a new cycle now. Um, and it'd be great to see in your book if that like is actually something that happens continuously, you know.
Yeah, no, I think that's right. I mean, I think, especially something you said in the beginning, which is like it was literally a narrative, is just like, why are we funding federal lawyers to sue underfunded cities? That was the hook. Part of the
Yeah,
hook is like the big bad federal government is giving money to these Harvard and Yale law school alums and Penn, I should say, because the
yeah,
training for lawyers was here at Penn. They're giving these fancy lawyers money to come sue these underfunded police departments, and these lawsuits are emptying municipal coffers. Therefore, we should end federal legal services. And so
right,
that was something that you saw. And I also think your point about the kind of the temporal aspect of the backlash is spot on in terms of the kind of slow erosion of civil rights by way of courts.
great. All right. Well, again, everybody, uh, buy that book, um, uh, uh, Law on Trial, and it's a pleasure talking to you. And yeah, I think people really have a lot to gain from your insights. So again, no Substack Live tomorrow. Back next Monday. Thanks, everybody.
Thanks for having me.
Thank you.